5 minutes, and I keep the time with this magical little device here. And once in a while, I'm known to zone out listening to your arguments and go, oh my gosh, the time's gotten away from me. But my job is basically to let the appellant know when they're beginning to encroach on their rebuttal time. So I'll do the best I can with that. Otherwise, I'll just keep the time and tell you when you're done, okay? So we are ready to go whenever you all are.
Dear Mr. College, hundred wishes, I would like to reserve 5 minutes for my proposal. I realize I have a speech ahead. So, let me know what you can understand. I hope you have a different repeat my word for you. Thank you. The facts are that Mr. Lantica is accused of sexual violence on 2 children under the age of 12. Sister Gigi happened in November 2010, despite 11 cases alleges the offenses were 2016 to 2018. But neither child both of these is 2018 when Gigi alleged that the boyfriend of a dependent sister had sexual about her. The things that now come to light as how she alleged sexual variations the defendant's sister boyfriend. Up until that time, the 2 families were really close, and the sister did not believe Gigi would cause the schism between the 2 families.
Did the trial court err here, or was it corrected by the allowing some testimony as to what the possible motive might have been, because there was an issue, some
Yes.
history with the families.
Thank you guys for that. Now, we argue that wasn't sufficient because the jury was uninformed. There was this schism, not the cause of the schism. And we believe that we have a right to present the cause of a schism to show the full motive behind. And if you look at the court's ruling, the trial court, they ruled that it was impermissible as a specific item context, and that wasn't what it was offered for. Moreover, no, the appellant wasn't commenting on whether the allegations against the boyfriend were false. the reason for presenting the evidence was to show that the sister did not believe the accuser Gigi, and that caused the schism. Now, so we were arguing that her allegations were false. That would be the specific act of misconduct. We were showing the circumstances that created the bias towards my friend. So we needed to show that she knew the sister did not believe her, and therefore that caused the break between this family, and that was the allegation against my client hers, even though they happened 7 years before with Gigi and 2 years before PG. We argued over error because of the content of credibility with the church and the icon to the issue. The next issue is the one that worries me the most. Because the improper use of
So on this issue, it seems that your concern is that the trial court erred in instructing the jury to consider charges involving PG as similar fact evidence as relevant to the charges involving Gigi, correct? So, but your client elected not to sever these charges and try them all in one trial.
Can I do that?
So I have a hard time understanding what the trial court could do in this situation, because the jury did, in fact, hear both of these, situations. So I'm not sure, the trial court was sort of left with a difficult situation, because there was no severing of this. These two were trying together. It gave an instruction that would seem to be called for. So help me understand.
I would be happy to. This first by the state chose to trial together. The state always had the decision whether to try the cases separately or together, right?
True enough, but couldn't the defense have sought a severance?
Why would they want to do that if the state can come back and use the evidence from 15 as collateral like they did here? My argument to you is evidence cannot be a charge offense and a collateral offense at the same time. They either
And
charge
what is the best case for that argument?
wonderful, 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 and full evidence about misconduct that will not be before court and they charge offenses, okay? If you allow the state to come in and you charge offenses as cloud offenses, then what do you need a ring for? A ban for only offenses that are not charged in the case before the court. And therefore, that's why you have a room for hearing to find out what the evidence will be. If you allow the state to do the cases, you are harmful both between the victims. Or you allow them to say, okay, consider what the victim and charge agent to corroborate what the victim and charge did. And yet they goes against the instructions to consider each charge separately. Is it not? Also, this is very important because of October 1st. These defendants who are charged with capital six battery will be eligible for the death penalty. So, you know, what I have built in bolstering for child victims through the child institution real that. And now the state wants you to allow them to argue, well, I'm going to try these two offenses together. And they ask the court to give instructions that they are collateral so that we can both cooperate with each other. The state is wanting to have its case and it's true. But they don't want to use one as windfall. Then they should charge it separately. It would have been ineffective assistance of counsel for the trial lawyer to sever the count. Exposing my client to what happened here, they say that's not what happened. And now should the state be allowed to introduce or to instruct the jury to consider evidence of one charge to be corroboration of another charge in the same thing. Do you have any questions for me? May I save my time overall.
Okay, you'll have 5 minutes, okay?
Thank you.
Thank you. Okay, what says the state?
In these courts, Jonathan Hurley, representing the Appalachian State of Florida in this case. Two issues in this.
Well, the two issues are pretty clear. If you don't
great.
mind, I'd like to just kind of jump in and
Let's
ask
get right
a question. The motion in limine is troublesome. The court denied the motion in limine and didn't allow, really interfered with the defendant's theory of the case, that the victim was not truthful, that she'd made this up because of a squabble between the families, and that she had accused a sister's boyfriend of the same type of behavior. And then the court more or less allowed questions all around that issue later during the trial. So, to me, the motion in limine should have been granted. I'll be honest with you. I mean, it should have been denied, I'm sorry.
The court abuses discretion.
Well, the question I have, is it harmful? Based on what happened as the trial went on. So if I view what the court did as an error, in other words, they should have denied the motion in limine, they should have let that testimony in. The question is, was it harmful in light of the other testimony about this subject matter?
So the issue is, did the court abuse its discretion when it tailored its order? And that's critical. It didn't outright deny, but that's specific to the Sixth Amendment and so forth. So to tailor its order by basically not letting the sideshow from taking over the circus in this case. The issue was bias, right?
In your
That's the
view,
issue.
that's what it is. In her view, that she was denied advancing her theory of a defense in this case, which in these cases, that's a pretty normal theory of defense. The victim's not being truthful. This is why the victim's not being truthful.
So, correct, but the issue is, and the applicability of using 96082 in this case is to allow the defense to show that there might be bias. Maybe that this victim has a motivation to lie. That's what was put forth. And the trial court allowed the issue of bias to come forth. And the bias was this victim disgruntled? Was this victim's state of mind disgruntled before?
That only came about because one of the questions that the victim answered, that didn't come about by the order. It was disallowed initially, but then when she made reference to a rift or whatever between the families, it was only then that those facts came out.
Well, I think what came out, there was no question that the court was going to allow the defense to demonstrate that there was a falling out, it's in the cross-examination, a falling out between the victim and the victim's family, and through that, there would be a bias, a motivation to lie because the defendant is related to the victim's family and so on and so forth.
The trial court said is that if the door is open, obviously you can go into that, and then what happened was the door maybe was a crack, as far as not fully open, and then the court allowed some cross-examination.
The court allowed the defense to inquire into the victim's potential bias. There's no question. And the bias was, you had a falling out with this family just prior to making these disclosures.
But it wasn't just a falling out, it was allegations of sexual battery as well regarding a family member, the boyfriend of the sister, right?
But the motivation to lie was that there was a falling out, that they were disgruntled with this.
Counsel, the problem is that families can have fallings out over all sorts of different reasons, banal and petty to severe, as apparently this would have been, and the caliber of attacking a witness's bias when the jury just doesn't know what kind of falling out was over, leaves us to wonder, hey, I mean, if maybe this would have put a seed of doubt in somebody's mind as to whether or not this falling out over a sexual battery allegation that wasn't followed through, maybe this is, this kid's attempt to get back at them. I mean, I just think it's a categorically different kind of falling out, if you will, than just generically saying they had a falling out.
I think we could all play Monday morning quarterbacking on this.
I don't know as much as quarterback. I think it is as much as it is just recognizing that they are categorically different things.
But there's a balance.
In courts of appeal, that's what we are. We are Monday morning quarterbacks.
But
We do this every day.
But this court also has to give wide discretion to the trial court's judgment below. No reasonable jurors would have ruled the way this judge ruled in this case. And the standard is wide discretion. And we're dealing with a sexual molestation child
Let me put it
case.
this way, an experienced criminal jurist understands interfering with the defendant's theory of defense. And they're very careful about it, and they try not to do it. And this looks perilously close to doing exactly that.
Didn't the court balance the interest in this case? Didn't the court consider, we're talking about the defense wanted to bring in question the victim, the child victim, about another case, another CPT interview in another city. I mean, it gets a little confusing at some point, just to prove that the victim had a motivation to lie, that the victim was disgruntled before she made her disclosure, which is exactly what the court allowed this to occur. And so there's a balance going on
So
here.
let's say we say there is error. So let's just assume there's error by the trial court in not allowing the defense to go forward with this theory of the case.
They went through the theory. I think you're mistaken.
Why is it harmless? I don't know that I've heard the answer to the question that Judge Morris posed.
Well, it's harmless is because the defense was still able to present their defense in their theory. The theory is that this victim had a motivation to lie because she had this wonderful relationship with this family, and all of a sudden that stopped. There was a falling out, and she was disgruntled just prior to the time of the disclosure, versus we're going to go into a whole sideshow about another defendant in another case who is the brother of the sister of the appellant. 1, 2, 3. We're really getting kind of lost in the weeds when we
I
start going down
recognize that
that.
would be inconvenient, but the defendant here basically had everything at stake in this trial, and his theory of defense was, she made that up, that's why she's making this up.
And they argued that. They were allowed to argue that, and they were allowed to cross-examine her on that. They just weren't able, they were not permitted to go down the details of this other incident with another defendant in another case. I mean, the court has a responsibility to balance the fairness also to this child, also to the state's case, in addition to making sure that the defense has a chance to present their theory of defense, which they did. They were not foreclosed. There's no Sixth Amendment violation here. They weren't foreclosed from presenting their theory.
How is Alvarado Gutierrez different? In that case, the court discussed Florida courts have recognized that a criminal defendant's dealings with a relationship to a third party, which here this would have been a third party, could bias a witness's testimony against him. So how are the facts here different than that?
In Alvarado, the trial court missed the pitch entirely. They applied the wrong law. They applied 9610 to that case, where in this case, the court correctly applied 9608 to apply the Pantoja criteria. in this case, we had a different individual that we're dealing with. The facts of the two cases were different. So then we get down to the third criteria, and that is whether the past allegations of abuse gave rise to a motivation to lie. And the court said, okay, let me look at this. Let's balance this. We've got a child victim in a child molestation case. We've got the facts somewhat extraneous on this other issue, but we're still going to tailor this order so that you can present your theory that the victim was disgruntled, and that gave her a motivation to lie and falsely accuse the appellant in this case. Also, in Alvarado, there was no tailoring of the eliminate order. They just outright said, no, you're not gonna, you know, it was an outright no. So in this case, this judge balanced, and again, wide discretion on how far this defense wanted to probe the details of this other crime. And
Was there any evidence that the victim, PG, that the allegations that she made against
Gigi.
Gigi, that she made against the boyfriend, the sister's boyfriend, that those were false, or shown to be false? Other than the families themselves, I mean, like, did she recant or any other extrinsic evidence of it?
no, and in fact, the record shows, according to the state, that this case was also going to be pursued in a separate case, meaning it's very confusing. You had in July, I believe, or June or July, you had a separate CPT interview in Bradenton. A month later, with these other Rodriguez, this other defendant, the boyfriend of the sister of the appellant. And then a month later, you had the CPT interview dealing with this particular defendant. So, I mean, even me trying to explain it is confusing. I'm just, so this is where the judge had to balance the weigh this out. And again, how far the details, the court has a lot of discretion on how far you can allow this defense to probe into this other act. And the court, I think, struck a proper tone in this case, saying, you're not going to go down to the details about some other collateral crime that may or may not have happened, but we know your theory of defense, and we're going to allow you to present your theory of defense that this victim was disgruntled and prior to the disclosure, therefore she had a motivation to lie, and which was argued during the closing. So the state of mind of this victim was presented to the jury, so they had an understanding. It's just how far are you going to let this go down the track on this child?
Can we move on to the second
Yep.
issue? Okay. Can you address Mr. Leidecker's counsel's argument that the two jury instructions and the similar crimes jury instruction only should be used where there's uncharged acts?
Well, first of all, the law doesn't state that. That's number one. We're not just dealing with Williams Rule, we're dealing with an expanded Williams Rule 9404-2B, child molestation cases specifically, and the allowance of corroboration as a matter of law. This is a statement of law. In opening statements.
But the jury instruction omitted the word similar, did it not?
The jury instruction.
It just starts with evidence, and so it was interesting to me that the actual, when you look at the 404-2A, it says similar fact, evidence of other crimes. And here, I think it just starts with evidence.
I'm sorry, could you read the statute you just cited?
I mean, I have it right.
404-2, but not 2A, not 2A. Not typical Williams, we're dealing with 2B.
Excuse me, 2B.
Yeah.
Okay. And 2B doesn't have the word similar.
It does not have the word similar. So that's what we're trying to say here. We're trying to say, basically, let's take the context of what happened here. First of all, let's back up and say we're dealing with abuse of discretion standard, okay? That's number one. No reasonable juror would have acted the way this judge did in this case. So, in opening statements, so we have severance, number one. This case should have, arguably, it was a tactical decision, according to the record, why the defense did not sever, but, so we don't know without having a 30-50, why exactly, but we can maybe presume that maybe this defense didn't want the state to have two bites at the apple in this particular situation. Who knows? I'm not going to speculate. But in any case, so they chose not to. And then in opening statements, the defense seems to suggest that all we have are these two accusations by these two different defendants. They're basically saying that we really don't have evidence of corroboration here, and that you need to basically consider the fact that we don't really have evidence of corroboration in this case. On cross-examination, the defense emphasized, you never asked your sister, you never told your sister about to PG, you never told your sister Gigi about this, and then when we cross-examined Gigi, you never told your brother PG about this incident. You know, this went on for years and you never said anything. No corroboration. Well, at that point, the state says, you know, in fairness, let's just state what the law is here. That there is corroboration in this case, as a matter of law. And the corroboration is the accusations made by PG and of a separate sexual molestation was corroborative of the testimony of Gigi. So the court is presented with a request by the state, and you can get in and look at McLean and 404 the statute. When a request is made, the law says you shall instruct. And so, was this an accurate statement of the law under 442B? Yes. Did the facts support this instruction? Was there testimony showing that there was two separate crimes of sexual abuse on the two separate victims? Yes. So now we get to the third criteria in determining whether or not there was an abuse of discretion, and that is, did the statement of law, was it necessary to allow the jury to properly resolve the issues in this case? As I said before, I think with this suggestion that there was no evidence of corroboration that the defense espoused, I think the state was allowed to clarify, yes, there was corroboration. And more importantly, this was not placed in the weighing of the evidence section. Your Honor, you talked about, I think the case was Gutierrez as a case to cite the Florida Supreme Court case 2015. And in the distinguishing, forget the fact that that was an adult crime, a different statute, and all the obvious distinctions there. The glaring problem with Gutierrez was that the judge granted this special instruction and supplanted it in the standard instruction on weighing the evidence. In this case, this was simply a statement of law that was made, a correct statement of law. This wasn't saying that this instruction is going to guide you in how you should evaluate the evidence. That's not what happened here. This whole separate section.
I'd like to hear and get your argument on this. I'd like to really quickly hear the state's thoughts on one thing. Suppose for a moment that we were to find a problem with issue 1 on the appeal that's here. It would seem to me that would only affect the conviction and sentence as to GG and not necessarily PG. But what are the state's thoughts on that?
Walk me through that a little bit. Sorry.
So we have two separate child victims. We have obviously the instruction, you're considering them separately. They're, even though they're being tried together, they're separate charges, essentially separate cases. Everything in issue 1 essentially pertains to the credibility determination of GG, the girl, not PG, the boy.
Right.
So if we were to find error as to not allowing the defense to pursue what you deem as a sideshow as to this other prior incident as to GG, would that impact or affect PG?
No, based on the facts here. But again, when you look at the criteria, the standard that this court needs to apply, I think it's a hard call to say that based on how this judge reacted in this case, that no judge would have done the same thing that this judge did in this particular case. And again, the defense was able to make, the key is, can the defense, are they given a chance to present their theory of defense? In this case, the victim was biased and she had a motivation to lie, and they did. And the question is, did this court abuse its discretion by not allowing the defense to go running down the gamut of details on this other crime with the boyfriend of a sister of the appellant? the state respected this court did not. There's no further questions, Your Honor. Thank you.
Your time is impeccable. You're right at time. Clarence, it's your time.
Thank you. I would like to say that our weather control and guide this court on issue one. Basically, everyone, what you have to decide there, Your Honor, and was the testimony given was of a specific act of misconduct as a particular, I can't say that one, and to the Supreme Court case, or was the evidence of bias? We would say it was evidence of bias because the appellant in no way commented on the truth of the allegation of the boyfriend, consensual boyfriend. And now, you will not have a conversation. It will be a simple question to the victim. Did the sister believe you when you accused her boyfriend of sexual abuse? Yes, that's it. You will now have a picture of the trial regarding the evidence that the defendant was not allowed to present, and the evidence was really to his theory of defense, and he was denied his right to confrontation.
Counsel, can I pose the same question that I asked the state to you? If we were to accept your argument as to this issue about basically the fact that, or the idea that the defense was not allowed to pursue its theory of defense as to Gigi's bias and Gigi's testimony, given that this is a separate charge, why would that affect the conviction and sentence as to PG?
Because Gigi's allegations, Your Honor, arose at the same time as Gigi did. If you go back, you look at the facts, they both presented remembers about the allegation at the same time. Gigi told her mom first, and Gigi heard that and told his mother. So it all comes together in her mind that, yeah, this, I see a point, but we understand that the allegation of both children arose at the same time. Also, during the CPC examination of Rodriguez's case, you did not mention anything about our funds at all. And that should have been allowed to be brought out. May I go into quick? Again, please be aware that bans will apply only to collateral evidence, not to charge crime. Yes, you can have charge crimes that are not a part of the instant case. That's why the defense did not sever. When rule is first charged, uncharged crimes that are not a part of the instant case. There's no case that you can find or I can find where this rule is given when there is no
Ms. Wiggins, you're out of time. If you would just close, please.
my would appreciate of an independent authority upon conviction with me for this trial. Thank you.
Thank you both. Well argued. Thank you. Appreciate it very much. Our next case is Reynolds Tobacco versus John Long.